You believe your doctor was careless and caused you significant harm and injury. And now, on a follow-up visit to your doctor, you decide to audio and video record him, trying to get him to admit that he screwed up. Is that a good idea, to audio and video record him? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, in all likelihood, no, it is not a good idea. Now, why is that? First of all, the moment you go ahead and start to surreptitiously, meaning secretly, audio and video record the doctor during a visit with you, you are now creating a Pandora's box. What do I mean? You are now creating the opportunity that anything that happens during that conversation now is going to be an open book. You may think that by not disclosing to the doctor that you are recording him and trying to entice him and trying to get him to answer your questions, to incriminate himself, to show that he did something wrong and to explain away why and how you suffered the injuries you did. Now you think that you're going to use this evidence and if your case goes to trial, now somehow spring it on the doctor and now everything will be great and that will be the end of it. The jury will have no choice but to give you a verdict in your favor. Well, let's rewind and go back for a few moments. Number one, when you have a conversation with your doctor, that is typically protected information. Why? Because there are specific rules and regulations and laws that protect those conversations. Now, you should know, if and when you do bring a lawsuit where you are now suing your doctor, claiming that his actions or inactions caused you significant harm and injury, your injuries and your medical history and your medical issues now become an open book. Not to the general public, but to the attorneys who represent the doctor and any other people whom you have sued. So, the fact that you are normally a private person, guess what? All of your medical issues and your medical condition is now going to be an open book. That's number one. Number two, during the course of your lawsuit, you will have to answer questions in a process known as a deposition. A deposition is a pretrial question and answer session that typically takes place in pre-COVID times in your attorney's office, or during COVID times, it takes place on a Zoom video call. During this process, where you are now being asked questions, the answers that you give represent your sworn testimony, and even though this may be done by a Zoom video call, your answers carry the same exact weight because it's sworn testimony as if you are testifying in court, at trial, in front of a judge and in front of a jury. One of the questions you are going to be asked during the course of your pretrial deposition will be, do you have any video recordings or audio recordings of any of the care and treatment that you received from any of your doctors? Now, that is a very dangerous question for you if you have gone ahead and video and audio recorded conversations with your doctor without asking permission. If you say no, now you have locked yourself into an answer. And if you think a year from now, when your case gets to trial, that you can suddenly spring this great evidence on the defense, and now you're going to win your case simply because you have now ambushed the doctor and his attorney, you are sorely mistaken. Why is that? Because trial by ambush finished many, many, many years ago. That is not permissible. That is not allowed. And if you were going to try and do that at the time of trial, the judge would likely sanction you and your attorney, for failing to turn over and disclose this evidence early on in your case. Now, what happens though if after you go ahead and start your lawsuit, you take this video and audio tape and now you exchange it, you disclose it to the defense, so they have an opportunity to review it before I have a chance to question the doctor whom you have sued? Is that permissible? The answer is yes. In fact, that's exactly what would need to happen. The problem is, if there are things that the doctor said in that video or audio recording that do not favor you and your case, you are going to have a problem. Now the defense attorney is going to do everything he can to show that you are a conniving litigant, that the whole reason why you are bringing this lawsuit is solely for the purposes of obtaining money, even though you have an absolute right to do so. But he's going to show that your methods of trying to do that are improper, maybe even illegal, and certainly unethical. If you audio and video record your doctor, and the doctor basically tells you he did nothing wrong, and the doctor tells you or implies that somebody else may have done something wrong, Can you use that information later to help you at trial? The answer is, if you disclose this information and now you are questioned about it, then the answer is you possibly could use it. However, the information contained in it may not help you. Instead, the defense is going to use that against you to show that you are trying to do things secretly. You're trying to do things not within the rule of law. And once you do that, now you destroy your own credibility. So let's get back to now you giving deposition testimony, where you will be asked whether you have any audio or video recordings of any doctor who treated you. If the answer is yes, well, guess what? Now the defense attorney is going to ask you lots of questions about when you recorded this, who was there in the room at the time you recorded this, did the doctor know about it, did you ask his permission, and now they're going to get lots of details about this recording. And then they're going to say, well, where is this recording? And if this particular discussion was not favorable to you, and you discarded or threw out or deleted this particular recording, now you've got a bigger problem. Why? Because now the doctor may have said something favorable to his defense that you didn't like, and that's why you deleted it. And now again, he's going to use the fact that you recorded it and then deleted it to show that you cannot be trusted. The moment you destroy your credibility through these efforts, you are going to have a major problem when your case gets to trial. Because now the jury will not be focused on the actual facts and the substance of what the doctor did or did not do, but rather they're going to be sidetracked about the fact that you may in fact have been conniving. You may in fact have been trying to entrap the doctor. You may have done something that you really should not have done. And if you did it, guess what? Now you have a trust issue. And the moment you have a trust problem, the jury is going to question how it's possible they can believe the rest of your testimony. If you cannot be trusted about something so simple as asking the doctor for permission to record a conversation, then how can you be believed about any other aspect of your testimony? And that is a very powerful message to the jury that you certainly do not want to get involved in. So why do I share this quick information with you? I share it with you just to open your eyes, because this happens from time to time, where an injured patient thinks that by going ahead and having a conversation with their doctor in a subsequent follow-up visit, now they can get him to somehow incriminate himself and not realize that he's on hidden video or audio and try and use that later on to win their case. You know, I realize you're likely watching this video because you want to enjoy the beautiful lake with me. Now, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet brought a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.